Good morning, everybody. 24th of December, 2025. Wishing everybody a merrier Christmas. My students at the Rockfield College of Sciences and Technology have asked me to use this material as a subject of study. This is about the recent dismissal of Dato Sri Najib bin Tun Abdul Razak's house arrest addendum order. Now, the judge in this case says in paragraph 26, premised on the position taken by the parties, there is only one pivotal issue in this judicial review proceedings, and that is the validity of the addendum order. Its validity or otherwise will in turn determine the enforceability of the addendum order and whether the applicant is allowed to serve his imprisonment term under house arrest. Now then, the judge starts off by saying, and this gets crucially, critically important, the proceedings before me raises the question whether a supplementary order to a pardon order made under Article 42 of the Federal Constitution is valid and can be given effect to. Now, Article 42 is very clear on the subject of pardons, respites, and reprieves. So let's get into the thickets and brambles and the nuts and bolts of what this is all about. Definition of a respite: relief from something difficult or unpleasant. Respite. Relief from something difficult or unpleasant. Hey, the jail sentence is unpleasant. I like to serve it at home. Royal prerogative of mercy. Article 42. Next. Definition of a reprieve: to cancel or postpone punishment. Do you need further elaboration, my dear students? The pardon, the prerogative of mercy, a respite, and a reprieve. It's very clear. Now, when the judge invoked Article 42, the royal pardon article of the supreme law of the land, she automatically invoked Article 182 subsection 2 and Article 182 subsection 7 of the Federal Constitution, which is the special court that only the Yang di-Pertuan Agong, the King of Malaysia, can summon, can convene. So in my opinion, the High Court had no jurisdiction to hear an Article 42 issue because the rightful decision and the appropriate venue for this issue should be the special court under Article 182 sub 2 and under 182 sub 7. You must read especially sub 7 of Article 182, the enormous power and authority of the Yang di-Pertuan Agong. So, my dear friends, if you ask me, this decision is unsound, unfair, uncomfortable, and there was no point raising Section 43 of the Prisons Act and all of the supplementary pieces of legislation because this is about constitutional supremacy. Students and practitioners of law, understand this. Malaysia, we do not practice parliamentary supremacy. All right, in England, Parliament is supreme. In Malaysia, the Constitution is supreme. So this is an Article 182 issue which should be raised by His Majesty the Yang di-Pertuan Agong and not by the judiciary. Thank you very much. Wishing all of you a merrier Christmas and a happier New Year. Goodbye.